Thank you, Chair Barnes-Delakia. As this is a very unique hearing or pseudo-hearing, you are going to hear presentations from us regarding the recommendation for terminations for 3 employees. The recommendations will come from a perspective, and the first time we share it will be fairly specific because these are 3 repetitive situations with the similar circumstances for each of them, with the laws that are indicative of why we are seeking this direction. I anticipate that the second and third hearings will be a little reduced in time from our position because of the nature of the repetitiveness. And so at this point, I would like to turn my time over to our Chief Human Resources Officer, Steve Herron, who will present our case for why this recommendation is before you.
Thank you, Dr. Cook. Chair, directors, and our esteemed guests. I want to start by communicating very, very clearly that district administration and the district bear no ill feeling towards any of the staff that we're discussing this evening. That's important to note. This, from the district's perspective, is strictly an issue of the district needing to follow the law, unless and until a court declares that the Oregon Health Authority's regulations regarding documentation of vaccine status are unlawful or OHA vacates those regulations. Superintendent Cook, myself, and others reached out to staff in numerous ways to ensure their clear understanding of the regulation that we were facing, to answer their questions to the best of our ability in supporting and their meeting those regulatory requirements. And this included group meetings, a WebEx town hall styled presentation, and one-on-one meetings for anyone who requested it. Tonight I'm responsible for presenting the basis for Superintendent Cook's recommendation, that basis being that each of the staff members, and in this particular hearing, Mr. Mark Schultz, ultimately elected to not submit documentation as required by the OHA administrative rule. Technically speaking, the ground for recommendation is insubordination for failing to comply with all laws applicable to the district. The citations to state law and district policy are set out in the 20-day notice that's dated September 9th that was sent to Mr. Schultz and that you were copied on. By way of background, as you already know, in August of 2021, the Oregon Health Authority adopted a temporary administrative rule that required all teachers and other school staff to either submit proof of vaccination or an approved, accepted medical or religious exception. That regulation prohibited schools from employing teachers and other school staff unless they had submitted the specified documentation. Another provision of the regulation required reasonable steps to protect folks from contracting and spreading COVID, so the district also required an affirmation that anyone requesting one of the 2 exceptions would follow mitigation measures. And the deadline for compliance with the regulation commenced on October 19th, 2021. This entire matter moved fairly rapidly from mid-August, when Governor Brown announced her directive to OHA, through mid-October when the regulation went into effect. And as soon as the regulation was issued and the district had worked out the mechanics of how to comply, we began communicating with district staff concerning the regulations and requirements. Our first email was on September 13th, 2021, and both acknowledged the regulatory requirement and prepped staff to respond to an email from Frontline Central, our personnel records management system. Our second email went out on September 22nd, continued explaining the process for accessing Frontline Central and uploading any of the 3 sets of documents that met the requirement. We asked that the upload be made as early as possible so we could assist anyone who was having technical difficulties in making the upload, but we acknowledged that the state's deadline was end of business October 18th. Our third email was on October 15th, informing a small number of staff members, Mr. Schultz included in this instance, that they remained among the employees who had not submitted documentation, expressing our sincere concern and desire to keep each of these employees working at BLS and working with our community's children. but we also clearly communicated that the decision to not submit documents would result in an initial placement on unpaid leave of absence, and that unless there was a change to the law or a change to their status on document submission, that would eventually result in their separation from employment at some point after February 20th, 2022. Our fourth email was on October 18th, informing staff who had not submitted the documentation that they would be placed on unpaid leave of absence commencing the next day, October 19th, and that eventually that would be followed by recommendation for dismissal. So I submit that there was a lot of communication about what the regulation was and what was necessary and what the consequences would be of the election to not submit documents. I should note here that we conveyed to anyone who submitted the documentation, or excuse me, we conveyed that anyone who submitted the documentation following the deadline prior to termination would be allowed to return to work no later than the beginning of the current school year, 22-23. And we did have an employee submit paperwork in January of 2022, and we were actually able to return her to work within weeks of that. In the meantime, the district and the teachers union were in the process of negotiating COVID-related working conditions for the 21-22 school year. And in January, the parties agreed that unpaid leave of absence for staff who had not submitted the required documentation would last through at least February 20th, 2022, after which the district could move forward with separation from employment. One question that has arisen is why the district has waited until now to move forward with the recommendation, and the answer is that in spring of 2022, Governor Brown lifted her requirement that state employees submit similar documentation, and we wanted to wait to see whether or not OHA would similarly vacate the requirement for school district employees. We had no desire to separate folks from the district and then see that regulation vacated shortly thereafter. But to the contrary, OHA adopted a permanent rule to replace the initially enacted temporary rule, and there's no evidence to suggest OHA is considering vacating that regulation. As such, at this point in time, the district unfortunately finds itself in the position of being precluded by state law from employing Mr. Schultz to teach our students in the absence of his submission of the designated documentation, and his non-submission therefore constitutes non-compliance with the laws that apply to the district, and as such, the election to refuse to submit documentation is an act of insubordination for which Dr. Cook recommends separation from employment.